The Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. Did you know live Senate video is now available at youtube.com/@Senate of Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. Did you know live Senate video is now available at youtube.com/@Senate of Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311.
This is a subcommittee, it's citing permitting subcommittee of the Sewer Commission on Electric Utility Regulation. And I think we need to, do we need to do a roll call?
Yes.
Okay,
Senator Deeds.
here.
Senator Surville. Senator Obenshain. Here. Delegate Sullivan.
Here.
Delegate Webert.
Here.
Delegate Munden King.
Here.
Mr. Josephus Almond.
Here.
We have a quorum.
Okay, the first thing on the agenda, and really the main part of the agenda is the director's update. I think we're going to consider we've been tossing a draft back and forth, and I think that's what we're going to hear about. Carrie, so take it away.
Okay. Good morning, everyone. Hope everyone had safe travels in this winter storm, and good to see everyone. Thank you, everyone, for joining online and here in the room. So my name is Carrie Hearn. I'm the Executive Director of the Commission on Electric Utility Regulation, and we have been making steadfast progress on reaching out to all of you as legislators and members of the Permitting Committee, as well as various stakeholders on this proposed policy. And we have posted an updated draft that has been reviewed and amended by Division of Legislative Services, along with the bill summary. So that is both in your packet and on the meeting materials site online.
That's the draft that's dated January 4, 2025, 4:12 p.m.
Yes, correct.
So we had somebody working on this on Saturday afternoon at 4 o'clock.
That's correct. Okay. Thank you, Tom Stevens.
Thanks, Tom.
Sleeping.
Good for him. Good for him. Good for him.
So I'm going to walk you through the high-level status of where we are today in the presentation, and you also have in your packet a summary that our staff has also put together in bullet points that explains the essence of what the policy does. So I think of this bill as coming in three main components, and of course there are details within each of these three areas. First of all, it does create the Virginia Energy Facility Review Board, which is a new political subdivision of the Commonwealth. And the review board has a variety of functions, first and foremost to review what are considered critical interconnection project applications and review them as to whether they qualify as having statewide significance. And so these are solar energy and energy storage facilities that meet a certain definition that is outlined in the policy. The review board reviews these and makes an opinion and provides that opinion to the local government for which the project is seeking an application. And there is a subsequent set of actions, but I'm going to go through the other key components. So the bill also looks at regional and local planning and policies, including zoning, comprehensive plans at the local level, as well as creating new regional energy plans, working with the regional planning district commissions, or PDCs. And importantly, the bill outlines if there were challenges to a project denial or a project approval or an opinion of the review board, it sets out an appeals process, keeping those appeals within the circuit court system, but putting certain time frame parameters on those appeals. So we heard the feedback from a variety of stakeholders that there was not interest at this time to move appeals to the State Corporation Commission. We heard that, we understood those concerns, and so the bill is very explicit in keeping those appeals within the circuit courts. The third main component is creating a technical assistance center within our university system. It would be housed at the University of Virginia, and it would include directors or designees from each and every public university in the Commonwealth, including historically Black colleges and universities, the universities that hold the local extension services for landowner support, farmer support, et cetera, and our research institutions. So those are the three main components. And I'll pause here if there are any questions.
Are there any questions for Carrie at this point? You just carry on and point us to the issues of controversy, I guess, within each section.
Okay, so again, this is updated slightly from the last iteration, and so we have laid out a proposed 11-member board, 9 of whom are appointed and are designated as members of the board, and the additional 2 are rotating members from local governments that are representative of where the project application is being reviewed.
And this part of the bill is lines 558 through 749, is that right?
I believe that is correct.
The Energy Facility Review Board.
Yes. So a few notable changes. We do have 2 of the 9 appointments coming from, one from the Senate Committee on Rules and one from the Speaker of the House. The other appointments are serving ex officio as a proxy of their appointment as a director of a state agency or one of those directors' designees. We also have an update.
Senator Obenshain has a question.
Yes.
So a couple of questions about that. One, I just noticed from your slide, it was hard in the short period of time since we got this to compare this version with the prior version, but I see that you have eliminated the State Corporation Commission rep. Why?
Yes, we had an extensive conversation with staff at the State Corporation Commission, and I made the determination that I felt like it was important for staff to not be included in this, given that they would be ruling on a similar application at a later stage, and it may put them in a potentially awkward position to provide an opinion at this stage, and then potentially, if new evidence was presented later down the line during the CPCN process, there could be potential differing of opinion at that time.
So I guess that prompts a couple of follow-up questions, Mr. Chairman. So because of the potential conflict of interest, where is the State Corporation Commission even in the decision-making process for citing decisions? I may have missed that.
So at this point, the policy does not include representation from the State Corporation Commission in this policy. The board is serving as an independent, separate political subdivision of the Commonwealth, and their information and opinions would be expressed later on during the state permitting process.
Okay, further question. So if it's a potential, and I think that's pretty tenuous, but if that's a potential conflict of interest, how about, and I think this is a new addition, the representative of a regional solar energy and energy storage trade association? Why isn't that a glaring conflict of interest?
So, Mr. Chairman and Senator Obenshain, we feel that the level of expertise represented in both number 3, an expert in energy economics, grid reliability, and ratepayer impacts, that is reflective of a similar set of expertise that the State Corporation Commission staff would bring. So we effectively lay out the type of skill set that we're looking for. And similarly, for number 8, we're looking for that deep level of expertise and subject matter expertise on the technology in energy storage and solar energy facilities. That could be a representative of a trade association or another representative, and happy to take your edits as recommended or discussion of the committee.
One final question on this subject. So I hear you on that, but isn't that, to my point, isn't it the potential conflict of interest also compounded by the fact that these organizations or potentially interested organizations can contribute private foundation and other dollars to the operations of the review board. Is there any mechanism to monitor or prevent conflicts of interest of that nature in here?
Mr. Chair and Senator Obenshain, I think that's a great flag, and I think having that expressly stated in the bylaws of the board could overcome that. And so if we want to express that in the policy as a directive of the bylaws, or rather require that the review board adopt bylaws.
And last.
I think Senator Obenshain still has the floor, then Senator Surville wants to.
I was hoping, well, I was trying to answer.
Hold on till Senator
Want to answer his
Obenshain.
question, okay.
And I guess last question is the bylaws, the Virginia Energy Facility Review Board would be the ones who are creating those bylaws, correct?
Mr. Chair and Senator Obenshain, I don't see this policy directing those bylaws specifically, and so therefore, yes, I would see the review board establishing their own bylaws.
Surville.
Mr. Chairman, it's my recollection reading this bill last night that there's specific language in the statute that says that the members of this board are subject to the Virginia Conflicts of Interest Act. Is that right? Maybe Tom might be able to answer it. I see him out there.
He's working on something else.
Mr. Chairman, my question didn't relate to the individual members, but the board itself receives these contributions, and I don't believe the Conflict of Interest Act has any application to a public board, and I don't think there's any mechanism in this for individual members to receive any money. I'm concerned about the funding of the board, and I don't think that is addressed.
Well, I'm just wondering if number 8, we could just identify that person as an individual with expertise rather than as a representative of Solar.
They are.
And spell out specifically that people with financial interests in specific projects in Virginia are not qualified to serve on the board, the Energy Review Board. Maybe we need to spell that out directly. Would that be closer to what you want?
It's a start.
It's a start. Okay. What do you think, Senator Surville?
I'm fine with that, but I also think, Mr. Chairman, that the Senator Obenshain's concern could be pretty easily addressed, amending, I think, 633 through 635, just adding some language there to say that the board itself is subject to the Conflicts of Interest Act, but
I think that would be good for them to have to list every contributor and the amount of the contribution made to them.
Line 633 says they are subject to standards of conduct to set forth in the state and local government Conflict of Interest Act and may be removed from office for malfeasance, et
That's
cetera.
the individuals.
Okay. Okay. Continue, please.
Okay, thank you, Mr. Chair. Thank you, Senator. So moving on from the proposed review board membership, we have some updated recommendations again per the discussion that Senator Obenshain brought forward from the last permitting subcommittee meeting relating to if an applicant is to be wrongfully denied and receives a favorable ruling, would they be entitled to attorney fees and actual damages? And so we have, again, looked at that and received additional feedback from other members of the committee and other stakeholders, and we've updated our staff recommendation to remove the section on actual damages and attorney fees.
And I'm sorry. And I appreciate those changes. One change that I thought we were going to make is line 338 through 340. The FOIA exemption, I thought that we agreed that that was going to come out, and I think in the earlier draft that we got last week, that did come out. Why'd that go back in?
So, Mr. Chairman and Senator Obenshain, I've also received additional feedback on this piece, and we believe that this piece can come out at this time. And so I had not heard that recommendation from the committee prior, but hearing it from you now, I heard it from Senator Surville. Perhaps I missed it from the last discussion, but I agree with the recommendation at this time. So we can, lines 338 through 340 propose to strike. Correct. It would remove that entire section by my read.
Yes, sir, Mr. Chair.
He concurs.
Mr. Chair, Tom Stevens, Legislative Services. Is y'all's intent for it not to be exempt from FOIA? Right. Okay. Because it's, I believe it's in another place too. That's right. So.
We'll take it out in both sections. Okay, it'll be removed from both sections. Okay, does that address the request? Okay, Mr. Chairman and members of the committee, additional changes that we are proposing at this time, or at least want to facilitate with respect to the discussion today, relates to standards of evidence and language around rebuttable presumption. We have an updated section around the appeals process, as I referred to before, with some dates and timelines that you'll see in there. We maintain the public hearing proceedings that occurs during the review of the critical interconnection project applications. And in addition, we heard from stakeholders that in the work group for creating the model ordinance, there's a request to include a ratepayer advocate in that process, so we added that in. So those are some notable changes that we wanted to flag for you here. On the next slide, I'll review the summary of the appeals process as we've amended it to date. So first, as I said before, we keep the appeals process within the circuit courts. Secondly, we say that appeals on locality decisions can only be brought forward by project applicants or owners of the property subject to the permit. So again, that is the same as what we presented last time, but part of this appeals process.
Senator Obenshain.
Yeah, so I understand that. So can you tell me how anyone at all could possibly appeal the grant of a application under this draft?
So, Mr. Chairman and Senator Obenshain, we restrict that ability in this proposal. So for the review board's decision, we do broaden it to include the locality, but otherwise it is the property owner or the applicant, so the project developer.
So nobody can challenge the grant of an application?
Mr. Chairman, Senator Obenshain, that is correct.
Mr. Chairman.
Senator Surville.
Thank you, Mr. Chairman. I don't do a lot of zoning litigation, but my impression, just looking at it from afar, is that the only other people you typically see appeal zoning grants are adjoining property owners. I'm not sure if you typically see anybody else appeal the granting of zoning applications. So if there's other people that ought to be able to appeal the granting of a solar decision, I'd be curious who that ought to be, but it seems to me opening it to anybody in the world.
Senator Obenshain's worried about people enforcing other people's private property rights. Let's hear it.
It's just a bit breathtaking.
Okay.
Mr. Chair, would you like me to continue?
Please continue.
Okay. Happy to hear other discussion on any of these. So keep interrupting me if you would. The third piece relates to, again, like I said, the review board's decisions, and that is expanded to include the locality in which the permit is being sought, again, relating to the appeals, the aggrieved applicant, or the owner of the property subject to the permit. The next piece is relating to the appeals being the exclusive remedy for disputing or enjoining the project. Further, we state that the opinion of the review board shall be presumed correct, that it may be overcome with evidence demonstrating that the locality's decision was consistent with the ordinance provisions and not based on unreasonable restrictions. And again, this bill sets forth a definition of what is an unreasonable restriction.
I think Senator or Delegate Sullivan had some questions and some ideas about that thing.
Thank you, Mr. Chair. I think this is where Carrie's headed on the next page of her presentation, where she talks about what the key considerations are with respect to paragraph, I guess it's B1. I'm happy to talk. So just to put them out there, and maybe Carrie can address them when she gets there. I think I know on line 539 what the words presumed to be correct. The language that at least I'm more used to seeing in my practice is that's called a rebuttable presumption. So it's a rebuttable presumption, which means the court presumes it to be the case unless it's rebutted, and then we go on to describe what kind of evidence could rebut it. So I just think, frankly, judges would be more familiar with the words rebuttable presumption.
The language would be better if it said in any such appeal, there shall be a rebuttable presumption that the opinion of the review board is correct, comma, as it relates to the factors enumerated in section A, subsection A of 45-1739. Is that?
Yes, that or similar language. My other question, Mr. Chair, which I raised with you, and Carrie and I have talked briefly about this. I know what probative evidence is. All evidence has to be probative before it even gets in. But I don't know what the word satisfaction of the court means. More importantly, I'm not sure a judge would know what we mean with satisfaction of the court. And so that's, I think, where we should have the discussion that's
You're more interested in putting some sort of standard of proof.
Exactly, something that our courts are used to. Preponderance of the evidence are clear and convincing. My own preference would be clear and convincing, but I'm mindful that might be controversial.
Senator Obenshain's finger happy. His fingers, trigger fingers.
I was waiting until
Yes.
finished.
Well,
Sullivan's.
I knew you'd want to jump in there. So go ahead.
Yeah, well, I mean, I see a couple of things in this, and I appreciate your clarification of what a rebuttable presumption is. I think you're right. I think this that does need to be clarified, but I'm also curious as to why we're piling on. You've got a rebuttable presumption, which is a very strong tool to support a position. But then we're also adding that in order to overcome that rebuttable presumption, you have to present clear and convincing evidence, which is, one step removed from beyond a reasonable doubt. I just view that as piling on and making it very difficult to overcome the decision of the review board. But I think that this also makes it impossible to overcome the decision of the review board, because it says that that the local government has to prove that its action was not or that it was consistent with the provisions, that it was not based on unreasonable restrictions as defined by 45.2-1735. And it's the review board that defines unreasonable restrictions. I find it hard to, and decides what's an unreasonable restriction. It just seems like we're always coming back to the review board and that the appeal is purely illusory.
Mr. Chairman and Senator Obenshain, the unreasonable restrictions is actually defined in this policy. So if we want to look at that definition, I think now would be a good time to look at that definition because we define that in this policy. The review board does not define unreasonable restrictions. So it's defined in this policy. And so that, page 23.
It's 587 to 593.
Lines 587 through 593. And I'd be happy to read this if you'd like.
Mr. Chairman. Thanks. I mean, I emailed you to Mr. Chairman a replacement for lines 538 to 42, which I think deals with both Delegate Sullivan and Senator Obenshain's concerns last night. I think that sentence would.
Okay, well, I apologize if I did not read your email. I'm looking at it right now.
Yeah.
You're saying
And Senator Deeds, your microphone is off.
I apologize. Lines 538, 542, Senator Servel's proposal is to strike and replace with, in any such appeal, there shall be a rebuttable presumption that the opinion of the review board is correct as it relates to the factors enumerated in subsection A of section 45.2-1739. Such presumption may be overcome by a preponderance of the evidence that the locality's decision to grant or deny a project or to include the challenged conditions was consistent with the provisions in the locality's ordinance that are not unreasonable restrictions as defined in section 45.2-1735. So your standard of proof is preponderance of the evidence and not clear and convincing evidence.
Yeah, and that there's a rebuttable presumption instead of that
The
presumption.
rebuttable presumption combined with the preponderance of the evidence seems like fair to me. What do you, Senator Obenshain?
Better.
It's better, okay. He's not going to agree, but it's better.
Better is good. And so do you want to look at the unreasonable restriction definition as well?
Unreasonable restriction over on.
Lines 587 through 593.
Well, I want to think about the appeal a little bit. We were
Okay.
just talking about the appeal being only to the, available to the developer or landowner, and it seems to me that Senator Obenshain has a point in that nobody's ever going to appeal the granting of a, and if we are time limiting the amount, we're putting this on a rocket docket, so to speak, when it gets to circuit court. What's the problem with having any aggrieved person having the ability to file suit?
Mr. Chairman, happy to take comments from other members of the committee.
Mr. Chairman.
Senator Servel.
Thanks. I'm not a zoning lawyer. I know aggrieved person includes neighbors, but does it include anybody else? I don't know what the standard is under zoning law. Maybe somebody else.
I'm not certain what it is either.
Why create a new definition for standing for this? Why doesn't the law as it stands, why isn't that good enough?
But Senator Obenshain's point is that somebody who files suit is still going to have to establish that they have standing to file suit.
Yeah.
And I think Delegate Webert's got a point.
No, that was,
Okay.
apologies. That was kind of my point.
Senator Servel. Senator Obenshain's point is that someone who files suit is going to have to establish that they have standing to file suit. That the standing law, the rules with respect to standing aren't changed just because someone has a right to file suit, but the 90 days, the expedited review still is the process. Why shouldn't anybody who's aggrieved have the right to file suit?
Mr. Chairman, again, the question I keep asking is what is an aggrieved party? And I know, I think it was our last hearing, I think it was Mr. Habib said something about how the way the current system is set up, the current system, not this system, the current system, nobody appeals anything because of the litigation incentives and the way the law works. And if we flip it around, it strikes me that everybody might appeal. And
But
the way these things are hotly loaded right now, and that's what I'm concerned about, which is why I'm trying to find out what's the definition of an aggrieved party.
Don't they still have to establish that they have standing?
Yes. It's a threshold determination for the
Set-
court.
Delegate Habib, if you've been involved with these cases, go ahead, please.
Sure, Mr. Chairman, members of the commission, Greg Habib with Gentry Lock, representing numerous associations and companies in the renewable energy industry. I'm not here to offer an opinion on the bill, but I will talk about appeals of zoning issues. So there is specific standing rules for appeals of zoning. An individual has to have what's called particularized harm. It's not a aggrieved party. So the way this is drafted, if they deny a zoning application under current law, the only people who could apply would be the applicant. So a denial appeal should only live with the applicant. That's the only person who ever could do it. If they,
Isn't that
existing law, existing law.
I state that.
Where it would matter is if they granted a permit. Under current law, the law is you can only appeal if you have particularized harm. The problem is every project now, when a permit gets granted, some landowner sues, and everyone gets dismissed on demur because the courts in Virginia have said there is no particularized harm for landowners in these cases. And so what you've done is created this unnecessary litigation step that clogs up the courts and costs money when, to my knowledge, and if I'm wrong, someone can correct me, every single landowner challenge of a granted renewable energy project permit has been dismissed on demur.
So is it your view that this language creates an unnecessary step?
This language eliminates the unnecessary step of the person without particularized harm seeking standing to bring suit, which will inevitably be dismissed on demur.
Senator Obenshain.
I'm not arguing with Mr. Habib. I'm simply making a comment. The reason that we give access to the court system to people is so that we can protect their due process rights. There are people who would have standing, who would be prevented from appealing under this language. Take, for example, and I can't possibly itemize every situation, but take an adjoining landowner who is going to suffer runoff damages from the construction of this project and can demonstrate that. That landowner would not have standing under this language. There are undoubtedly dozens of other situations which will be foreclosed with this language just so that the industry can prevent some people from challenging the decision. I just think this is contrary to our American system of civil justice and our participatory democracy. I just think it's just fundamentally wrong.
Delegate Munden King.
Thank you, Mr. Chair. So, listening to this conversation, I've really been a little hesitant. There's part of me that says just let the lawyers have their fun, because it seems like y'all are having a lot of fun. But I want to call out a couple of things, and thank you to Delegate Habib for clarifying that. What we have right now is not working. And I'm hesitant because I'm not sure where I stand on this particular bill, so I don't want to make a bunch of suggestions that I might not vote for anyway. But what we have is currently not working. And the idea that my neighbors are continuing to bog us down in court cases over what happens with my land is becoming somewhat of a circus here in Virginia. And so wherever we land, I think clarity on where my rights end, where yours begin, and who has standing would be very helpful. Because this circling around about who can go to court in 90 days here and then another 180 days here for a property that belongs to me is problematic. And so I'll let the lawyers figure out the specifics, but I hope we can, think about property owners and their rights to develop or not their properties.
Mr. Chairman, to Senator Obenshain's comments, and as he well knows from our time serving together, very few people love the Virginia civil litigation system as much as I do. and we do litigate these cases, there actually is very, very, very limited standing under current law to challenge the grant of renewable energy project. Again, I'm not aware of a single lawsuit that's been filed by a landowner challenging the granting of a permit that hasn't been dismissed on demur, because you have to have such individualized.
In Hanover County.
So the Wegmans case was a couple years ago. That's the new standard, which didn't change. That's the latest case, which has been cited in numerous renewable energy projects, and cases are still being dismissed on demur. So notwithstanding the Wegmans decision, since that, we have defended multiple challenges to renewable energy project permits, and I'm not aware of a single one where a court granted a landowner standing, because they're not going to have that individual particularized harm to have standing. Again, the lawyers would love it because it's an extra step in litigation. So if you leave the current law in place, you could have any citizen, anybody could file a lawsuit, a demur would be filed, that case would be dismissed on demur for lack of standing, and all you would have done is paid some of us some money and delayed the project a little bit longer. But that's a policy decision for you all to make.
Delegate Sullivan.
So summarizing what I think I've heard from the bench, from Carrie and from Delegate Habib, it sounds like if we were to put the words particularized harm into the statute, we would be codifying the latest Supreme Court ruling. And I guess my question might be for Senator Obenshain, would that satisfy your concerns that we would be leaving the law unchanged with respect to current land use
Why put it in the statute then, if that we're trying to codify current law? I mean, the court's done a very good job, I think, of stating standing. I mean, it's surplusage. It's not necessary. I would say strike it.
So the Senator, your suggestion would be say nothing about aggrieved, what kind of aggrieved landowners could, and just rely on the current ruling of the Supreme Court, the Wegmans case?
I would not potentially restrict standing.
Thank you, Mr. Chair.
Mr. Chairman, just one other point. Taking off the hat I was wearing before, there's a lot of business organizations who do not want you to codify the Wegmans case, who would be very disappointed if Virginia codified the Wegmans case. So just a thought, be careful how far you take the Wegmans case, because that case is not usually used to disrupt renewable energy projects. It's used to disrupt economic development projects in a lot of your districts.
Delegate Habib, let me ask you another question. Going back to lines 543 to 547. I mean, in the 90-day expedited review, doesn't that cure whatever problem you've got, whether whoever can sue?
So, Mr. Chairman, members of the commission, right now you have 30 days to file suit to challenge a local government's decision. So the plaintiff would have to file that. You then have your normal demur procedures. So you could set an expedited demur process for that standing to be determined to make it happen within that 90 days. The suit will have to be filed within the 90 days. That's not a problem. You already have to file that challenge within that time.
This says any appeal, any decision has to be made decided by the circuit court no later than 90 days from the date of service on all parties. So once suit's filed, you have 90 days to get the case resolved by the circuit court, one way or the other.
Correct. And the question is, can you within 90 days not only handle the substantive side, which is what this anticipates now, but also the procedural standing question? And if you tell the courts to do it, they'll do it.
They'll do it. Senator Obenshain.
So I wasn't going to get that far down into the weeds, but the expedited hearing process, I mean, for goodness sakes, what else are we going to do for one industry? I mean, we just created a general jurisdiction in the Court of Appeals for every case that is brought, expanded their jurisdiction. We just increased the caseload for circuit courts all over the Commonwealth of Virginia. Other litigants can't get trial dates in circuit court, and once they get a decision, they can't get a decision from the appellate process for, I guess if it goes to the Supreme Court, it's about 4 years. And this is going to further back up the civil justice process for everybody except for solar developers. I just don't understand why we are breaking our back to, at the expense of everybody else in Virginia, to get to this point.
Well, I'm not sure that a compromise with Senator Obenshain is going to solve the problem. We're still going to end up with a bill that Senator Obenshain is not going to support. But it seems to me that a reasonable compromise would be to say that anybody who right now can sue can still sue, but they're still subject to the expedited review.
And you may be right, but I appreciate your listening.
Mr. Chair.
Delegate Sullivan.
Thank you. Just to clarify, because I saw Delegate Habib's hair catch on fire.
What hair?
This is beard that caught on fire. Yeah. No, I was simply exploring where Senator Obenshain was. I wasn't suggesting codifying Wegmans necessarily. But in response to the senator who, and I appreciate all of the comments you've made, Senator. I think it's going to end up making the bill better. I understand it may not end up getting your vote, but I view that as part of this process, that when folks like you who make good points like you've made, it pushes us to write better legislation. So I really do appreciate it. I would just say that I would take issue with your suggestion that this is being done at the request of an industry. My own view of this is that this is being done because, at least in my view, there is a problem that we now face in Virginia, accomplishing what the state has set as in code as a priority for this state. And this issue lives at the intersection of statewide priorities and goals and local land use decisions. And the state goal can't be implicated without local decisions, or certainly can't be accomplished if localities don't enable it or decide, or enough of them decide they don't want it to happen. And these are the same localities who welcome data centers but don't want to approve a solar installation to help power that data center. So in any event, I'm making a speech more than a question here, Mr. Chair, but this is being done, I think, because what we're doing is we're looking for a way to facilitate the implementation of a state goal, and we're trying to solve a problem for the entire state, not just for an industry. Thank you, Mr. Chair.
Isn't that so? I think Senator Servell has another idea about the last 543, 547. He says we need an enactment clause that directs the Supreme Court to develop rules or to adopt rules to handle these appeals, consistent with the provision of the code. I think that makes sense.
Thank you, Mr. Chair.
Okay, Carrie.
Okay, Mr. Chairman, thank you. So continuing on, we are, I guess, now find ourselves with the question around standard of evidence. So moving forward to Delegate Sullivan's point around the scale of preponderance of evidence or clear and convincing evidence. So if you could just remind me where you're at with respect to this section.
I think Senator Servell states probably more eloquently what I tried to state without looking at his email, and that's contained in his the bullet that says on 538 through 542, you strike that language, replace it with language that says that in any such appeal, there shall be a rebuttable presumption that the opinion of the review board is correct as it relates to the factors enumerated in Section A of Section 45-1739. Such presumption may be overcome by a preponderance of the evidence that the locality's decision to grant or deny a project or to include the challenged conditions was consistent with the provisions of the locality's ordinance. There are not unreasonable restrictions as defined in Section 45.2-1735. It kind of strikes the balance. It doesn't go as far as Delegate Sullivan wanted to go, but it contains the rebuttable presumption language, which is more like what a court is going to have to deal with.
Thank you for clarification. Okay, so moving on. The question here is around the membership of the review board and who is given the voting authority on that review board. And so the question is if the local government representation on the board should be a seat that has a vote or that is a seat that is there to inform the discussion and participate. But given that the local government is going to be making the next step decision, should that local government representation have a voting seat on the board? So this is a question that's been raised from a couple different parties, and I wanted to bring it forward to you all to give direction.
My own view is that if the local governing board is having, if they've had to vote on the situation, or they've had to vote on the applicant, they should not have a vote on this. They should certainly be at the table so they can participate in the discussion, but they should not, it would be an inherent conflict of interest to have a vote. Others may disagree. So, Mr. Allman.
Mr. Chair, thanks, Carrie. Yeah, I agree. I think because they still retain decision-making authority on the project ultimately, I think we do want their input in this review phase, but don't think they need a sort of vote at this step since they do get to make the final decision down the line.
Okay.
Delegate Weber.
Thank you. All right, so the current makeup of the board is 9 members?
9 members plus 2 rotating members of the locality where the permit is being sought.
And so the discussion is that those 2 members would not have a vote, so only 7 members would have a vote.
It would be 9 members voting and then 2 non-voting rotating locality members. So 9 plus 2, 11.
Okay. This review board is going to look at the applicant, but the applicant in theory would also be trying to put in a facility under a ordinance that we've already determined what they're going to adopt within range. And that ordinance is whoever comes up with the ordinance, and we're going to say localities, you have to adopt this as part of your PDC or your planning commission district or whatever it is. And then we go to this, and it seems like if you're going to have 9 plus 2, at least one of those local folks should have a vote, because simply you're literally having people that may not or may not live in that locality or in that region voting on a project that's going to affect numerous people. And so that locality should have a say. And that way they don't feel like, at least, that they're, being forced to do something.
Delegate Weber, don't they ultimately have the say, though? Locality has to decide?
Well, ultimately, they don't really have a say anyway, because we're telling them that they have to adopt an ordinance.
Senator Obenshain.
So, since you're asking for my feedback, I think it's important for them to have a vote on this. When this, in the original iteration of this, there was concern that we were taking away too much from local governments, taking away too much of the decision-making authority, taking away too much of their voice. And I thought that this was added in order to address that, to give them more of a voice. And, I think that it is important for them to have a vote. And I think that, we're backtracking from the direction that we were headed if we were to remove the ability of the local officials to have a vote. It's just my opinion.
Delegate Sullivan.
Thank you, Mr. Chair. Candidly, I hadn't given this a lot of thought until this morning. I either didn't know or forgot that it was on our list of open issues. On this one, I find myself aligned with Senator Obenshain. I don't see a conflict per se in the sense that if they're going to vote no in one forum, they're going to vote no in another forum. I don't know that gives you conflict. That happens to us all the time. And some of us even switch our votes occasionally. So I had seen this when we added it as enhancing local participation in this process generally, and amplifying the local voice in this process, because this is the board that's going to make a recommendation to the localities, and to have the localities represented by two people who have an actual say in what the board does, to me, makes sense. So I don't know if you're counting noses or how we're going to make these decisions about what goes in and what doesn't, but my inclination is to have both of them vote.
Okay, does anybody else need to be heard on this issue? I think that the consensus is that we leave the voting in.
Thank you, Mr. Chair.
And I are the only two that have spoken opposed to it.
Mr. Chair, I may offer, you could, as a further consideration, have one of those seats representative of local community-based organizations or constituents, or, described in some such way, but may not be the local government official. But I hear that you all are leaning towards having 2 seats from that particular local government. Certainly, there could be a permit that would cross boundaries, and so you would have 2 seats that would enable representation from multiple jurisdictions.
Senator Obenstein.
I would oppose that. We're talking about the people who've been elected by the residents, by the voters of that jurisdiction, and taking away the vote from them and giving them to some cherry-picked, hand-picked individuals representing some organization that may have a issue-based bias. I think we ought to trust the voters of the locality.
Mr. Chair, Senator Obenchain, thank you. Appreciate that clarification. Okay, so we will keep those 2 local seats as both rotating but also voting enabled. Okay, thank you very much. So the next discussion is a new discussion. It was brought forward by representation from the Municipal Electric Power Association of Virginia. And as you may know, we have a little over a dozen local utilities that are public utilities in municipalities. And so I'll just read what you have here on the slide, that some cities and towns function as both a locality and an electric utility. They have long-term wholesale power contracts governing the terms and conditions for purchasing power that restrict or limit other power purchases. And MEPAV, the Municipal Electric Power Association of Virginia, has expressed concern that the bill places restrictions on localities that could also impact that particular locality's electric utility, e.g. the size and type of power supply options. And so the question before you is whether the draft legislation should clarify that localities operating an electric utility are somehow exempt from the requirements of the bill. And I will say we just received this question recently, and so staff has not further investigated to present a staff opinion, but we put forth the question for you.
Carrie, which localities we're talking about? I mean, have there been?
For example, Bedford, Danville, I think there are maybe 13.
Bristol.
Correct.
Yeah. Yeah, Tom. Yeah. And let us know whether there have been fights over the placement of renewable energy facilities there.
Well, first of all, I think this broad issue has been more of an issue in counties when, a lot of cities, of course, are landlocked. But there are, there are 95 counties in the state, 38 cities, over 200 incorporated towns. There are 7 cities that own and operate their own electric utility and 7 towns that do so. There's 1 authority and 1 state agency. But Danville, Franklin, Harrisonburg, Manassas, Martinsville, Radford, and Salem are the cities, and then Bedford, Blackstone, Culpeper, Elkton, Front Royal, Richlands, and Wakefield are the towns. And so, I don't think the bill was intended to come to us, but
I wonder whether there would ever be a fight over the placement of a solar facility in any of those localities.
Well, I'm not sure, but because there's a model ordinance requirement, and these localities have to establish one, and we're not sure what's going to be in the model ordinance. There was concern about who do you have to hook up and how the interconnection. We just didn't want anything to affect the utility operations for this very small segment that's out there. So
So you just want an exemption from the provisions that require you to adopt the model ordinance?
that's right. Well, they don't want that to impact them. And we have, Danville's got 25% renewable power, and right now Franklin or Town of Front Royal, renewable has a place there, and they're working on that. Although I don't think Danville can, at the present time, can do more solar because of their system. But we certainly support renewable energy, but we don't want them to be. Would rather not have the requirements. We were concerned that it was going to restrict them and require them to do things. And they've been doing this for over 100 years.
Let me ask you, Kerry, this only applies when there's a site that's more than 10 acres that's impacted?
2 megawatts.
2 megawatts would be
So are there localities that would have sites that big? I mean,
Well, there are some that would have that. I think they're, I'm not sure. If Danville has those sites available, there's some in Franklin. There are some sites that are bigger or within their service territory. I think there's potential there that they would have that. So there's a lot of questions about how this plays out because it's speculative on the ordinance.
for open chain and Delegate Sullivan.
I have 6 localities who would like an exemption too.
I understand, but there are only a handful that operate their own electric utility, and we just don't want their electric utility to be impacted. I mean, they've been doing this. Some of them, Danville's been doing it for over 100 years, and they were concerned with how it might impact their utility operations, and we didn't think it was intended to do that. And the instances of it, it wouldn't be frequent. I don't think it's kind of remote, but.
Thank you, Mr. Chair. So, sir, let me ask you, as I've listened to you talk, it sounds like the localities or the local electric utilities concern is more with the local ordinance. And so is the answer here to not necessarily exempt them from the whole process, because there may come a time when one of these localities has a more than 2 megawatt facility. But in our language, I don't know what I'm suggesting, frankly, but in our language relating to the local ordinance, we could have some recognition, which might sound also a little bit like an exception that says in those instances in which the locality is also the electric utility, they shall get the following relief.
Something like that would
help?
Something like that would certainly be helpful. That was a concern. I didn't want to, and I don't have language prepared today to.
That makes 2 of us.
To address it, but something like that would be helpful. Our localities are supporting it. Danville has, they serve some in Pennsylvania County, and they'd work with Pennsylvania County to have solar projects sited, and for localities who can't get that, that tax credit that's available from the federal government, they use a private developer to do the project. They just buy the power from them, so they work on getting those things approved, and so they do. We do support the use of solar power.
Well, Mr. Chair, that simply would be my suggestion, is that we ask staff and council to work together to make sure that we're not inadvertently hampering localities that also are a utility in the local ordinance or the model ordinance process.
That would be very helpful. I appreciate it. Thank you.
Thank you. Okay, thank you, Mr. Chairman.
Mr. Chair, just real quick. Is the primary reason that because the locality that also operates the utility doesn't have the space for a solar facility?
I'm sorry, could you repeat that question, please?
Oh, so you've got a small locality like the town of Front Royal, and if they're operating, this is just an example, I don't know if they do or not, I thought I heard you say it, but they're operating their own power utility, right? So they're buying power for their constituents. Mm-hmm. And the primary reason that they can't participate is because there's no place for solar, correct?
Well, that would be one reason. I mean, they have all of our utilities. They have long-term wholesale power contracts that restrict what they can do and what they could connect to their system. And so there are restrictions there on those private contracts that they've got. So I don't know. In Front Royal, I'm not sure if there's space there for something that's been an issue with it.
But what would be an example of one of those restrictions?
Well, I think the size of the connection, maybe the interconnection agreement itself, being able to buy solar output, if you have a wholesale power contract, all requirements contract from Dominion, for instance, you're limited on what you can get anywhere else. So even if you wanted to do something, you'd have difficulty unless you got approval from Dominion, to connect some solar to that. So you have that conflict with the wholesale power contract right now. What could be required in an ordinance
So that's more an issue with the actual grid of the city,
with the actual
grid structure of the city.
yeah, I guess so. That and the wholesale power contract, the private contract they have for power.
My understanding, I mean, and correct me if I'm wrong, but I think your problem is that because each locality is a utility, you have long-term contracts to buy power from, say, Dominion or somebody, and you're afraid that the requirement to grant these solar fields, even though you really don't have space for them, the requirement to do it might interfere with your long-term contract to buy power.
It would be a conflict there, yes, sir. And we'd like to avoid that.
I get it.
Mr. Chairman, he may also be, I know the model ordinance was brought up as an example, but in our view, the meaningful contributions that we're looking for from the regional planning district commissions and also contemplated in the local comprehensive plans are connected to the Commonwealth Clean Energy Policy and as such, looking towards the Virginia Clean Economy Act. Of course, the Virginia Clean Economy Act does not apply per se to local municipal utilities. It is only looking to the largest investor-owned utilities.
So you just mentioned the regional energy plans and the Commonwealth Clean Energy Policy. Just before I forget about it, two things that concern me. One, there are multiple places, including the 15.2-4209.1, the Regional Energy Plan section, that essentially makes the Commonwealth's clean energy policy a mandatory policy. Multiple places through here. The express language of the statute creating the Commonwealth's clean energy policy says it's purely advisory and never was intended to carry any sanction or be mandatory. I'm concerned about that conflict with existing law. Second, you point out that the regional energy plans are developed by the planning district commissions, but that's not really true. When you look at the power given to the review board, it expressly says that the plans developed by the planning district commission have to be consistent with the report issued by the review board. So isn't it the review board that's essentially mandating what the planning district commissions are allowed to include? And then the review board determines whether the regional energy plans are consistent with theirs. So they set it, they develop the plan, they impose it on the planning district commissions, and then they decide whether the planning district commissions were true to what their projections were.
So, Mr. Chair, Senator Obenchain, hoping to clarify our intent, and if there's anything inconsistent with our intent in the bill, we're happy to modify it. But let me share my vision for how this works. So the Commonwealth Clean Energy Policy does ask localities to contemplate in their comprehensive plans how they will be making a meaningful contribution to state energy goals. And as I've said previously, we don't believe that that is effectively happening across the board in all localities right now. And so this policy does set out a framework whereby, with technical assistance from both the state and the regional PDC, local comprehensive plans can now further enable their contribution And just one more thing, because I want to clarify, I want to make sure that this is understood. The vision for the statewide modeling is to be updating our long-term 2050 decarbonization goals and then backcasting that statewide process to an annualized, or let's say every 3 years for the regions. So it splits it into regional big picture goals that helps us collectively stay on path towards mid-century goals. But the regional planning district commissions do have the pen and the power to define what that looks like within their region. So the Hampton Roads region is going to look very different from Northern Virginia, and that will look very different from Southside or Southwest Virginia's regional plan, because they have different attributes, they have different populations, they have different demands, and they have different geographical makeup, they have a different type of building infrastructure, and their energy resources are very different, ranging from offshore wind to on-site building energy management to abandoned mine lands in Southwest. So we're really encouraging the planning district commissions to work with their local governments to help define the portfolio of energy resources, including energy efficiency, emerging technologies, and everything in between. That's where they chart out how they're going to reach that meaningful contribution goal that the state helps set. So it's a balance between regional planning of articulating the nuance in the portfolio to meet what may look like a sort of state-defined overall generation goal to help keep everyone on track.
With respect to the Commonwealth Clean Energy Plan, don't you have to amend the statutes that created that and strike out all of the language that says that it's purely advisory, and then strike out the portions that say there are no penalties or sanctions that are available for non-compliance with the plan? Shouldn't that be in the bill too?
Mr. Chairman and Senator Obenshain, we don't believe that we need to get into modifying the Commonwealth Clean Energy Policy, but rather support through offering technical assistance and budget dollars to support the planning through this articulated process as we define the regional energy plan.
So to Mr. Habib's point,
Senator Obenshain.
about litigation, I don't support taking that out, but if you leave that stuff in, aren't you just creating a quagmire for the courts? I can see litigants trying to argue that, wait a second, the Commonwealth Clean Energy Policy statute expressly states one thing versus the citing statute that was just adopted by the General Assembly states something else with respect to whether it's mandatory or not. Why create that potential for litigation? Why not just say what we plan to do and just scrap all of the advisory language and create a hammer?
Mr. Chairman, Senator Obenshain, I see the appeals process and the litigation questions more applicable to the zoning ordinance and the permit applications. But I would like to maybe have you clarify your question looking at the code section to see where you're seeing that pathway in the planning process. Because we may be mixing zoning ordinances and permit applications with the comprehensive planning and the regional planning.
I'll happily go through that with you offline.
Thank you, Senator.
Mr. Allman.
Thank you, Mr. Chair. And Carrie, as I'm reading this, I just did a quick Control F for all the references to Commonwealth Clean Energy Policy. Nothing in there seems mandatory to me. It seems all the sort of verbs are shall consider and shall ensure is consistent with. And so to the extent that it's not sort of making any binding finding with respect to the Commonwealth Clean Energy Policy, I would think it sort of doesn't run afoul of it.
Mr. Obenchain, Senator Obenchain wants to,
So line 505 to 508, for example, by July 1, 2026, each locality shall adopt an ordinance for the permitting of solar energy facilities and energy storage facilities that is consistent with the clean energy policy established in 45.2-1706. That is mandatory.
and Senator Obenchain, I think you were looking at an old draft. It's lines
The one I
50
got over the weekend.
Yeah, well, the one on
Line
January
509.
4 is 509 through 514 is what he's talking about. The requirement of a draft of an ordinance is what he's talking about.
And the content of the ordinance, it is mandatory that it shall comply with or shall be consistent with.
The boards.
And as we, are there other instances in state law where we require localities to enact ordinances? Yes. Where? Tell me. That's what I was trying to figure out. I just don't do enough local government work to know.
This may be a question for our local government expert at DLS that we can consult with.
That's not me.
Jeff Sharp.
I just wondered whether we require local governments to develop a plan, a comprehensive plan, but are there instances where we require them to adopt ordinances?
Mr. Chair, again, Tom Stevens, Legislative Services, not the local government expert, but if you look at section 45.2-1708, current law in the development of any local ordinance addressing the siting of renewable energy facilities that generate electricity from wind or solar resources, such ordinance shall, subdivision 1, be consistent with the provisions of the Commonwealth Green Energy Policy.
So we tell them what it needs to be consistent with, but we still allow them, we don't mandate that any ordinance be adopted.
Correct.
And so the change here is we would be mandating the adoption of an ordinance consistent with a model ordinance.
Well, that's not my point. My point was...
Senator Obenchain.
My point was it requires the ordinance, when adopted, to be consistent with an act, with a piece of legislation that expressly states that it is purely advisory.
Mr. Chair,
Delegate Sullivan, please.
I don't know that we're going to solve this today, but it sounds to me like the senator would prefer to just repeal the clean energy policy, which is a goal, and that's what this language in the draft we're looking at right now simply says is those are a goal of the Commonwealth. By the way, enacted separately from the Clean Economy Act, and the model ordinance ought to be consistent with that goal. That's all it says. It doesn't turn those goals into anything mandatory, but it's long been that. I believe the clean energy policy predated the Clean Economy Act. It's long been the goal of the Commonwealth, as set forth in that energy policy. This simply says when you draft your ordinance, it's got to be consistent with those goals, and I don't think that makes anything mandatory.
If you don't do it, you're in violation of the act. It's pretty mandatory.
We're now on the ordinance, I assume, that section, we're going to look at 509 through 523, which you got a January 3. Tom, you worked all weekend. Oh, gosh. January 4.
So that's one that we didn't get till this morning.
No, it got yesterday. I got this yesterday. It's January 4 to 4:12 p.m. You're looking at 509 is where it starts, where the ordinance starts.
So, Mr. Chairman, I don't have a slide or recommendation prepared for this discussion, but I'll take your all's
Okay.
recommendation or questions. Happy to go over the policy is drafted. And these have been in, Tom may correct me if I'm wrong, but these have been in the proposal for quite some time.
So they're new lines, but not new language.
Correct. That is correct.
This is the same language. Senator Obenshain was looking at January 3. It's the same language. It's just different on different lines.
I believe that is correct.
Okay. Delegate Weber has a point.
So just run me through what, so basically right now, the language as I see it, the only thing that it says that they have to adopt a model ordinance. There's a model ordinance that's adopted by the Virginia Energy Facilities Review Board. That's the same review board that would oversee the facility, like if they're putting in a facility and they get rejected, then they,
Correct.
Okay. Who votes on that model ordinance? Because you now have two in that, when it comes to the facility, you have two local folks, but now you've got statewide concerns that, as you pointed out earlier, Fairfax is a whole lot different than Bristol or, Washington, Virginia, and you're adopting ordinances there. I mean, what do we see as a
Mr. Chairman,
stipulation for that?
Delegate Weber, I hear the question in terms of how are different local governments represented in the creation of the model ordinance? That's the question. So the newly established Virginia Clean Energy Technical Assistance Center, this university consortium, would be one of the main groups that would be helping to draft the model ordinance, and there would certainly be stakeholder representation from interested parties that could include the Virginia Association of Counties, conservation groups, other industry representation, et cetera. And then ultimately it is the review board which adopts the final model ordinance, but it does go through a process, a public process, if you will, for creating that set of standards, for creating the statewide standard. But I don't think we contemplate who are the local representatives on the board for that vote per se. And I agree that it may be a gap in consideration of who is the local representation on the board at that moment.
But you anticipate that the board would develop a regional plan, or develop a model ordinance, and there's nothing in here that says they have to adopt the model ordinance. It just says they have to adopt an ordinance consistent with the model ordinance. Is that right?
So the Virginia Energy Facilities Review Board does adopt that model ordinance.
Okay, but the localities don't have to adopt the model ordinance. They just have to adopt something consistent.
Yes, so the statewide model ordinance gives a range of parameters.
Okay.
And so it sets sort of a floor and a ceiling for these different subject areas, whether it's fencing or buffers or wildlife corridors or what have you, that is based on research and industry best practices, conservation best practices, local government input, and then the local jurisdiction is able to sort of select a finite number, if you will, if that's the case, in this broader range that the model has set forth.
Senator Obenshain.
I went through and made my notes on the version I got at 6 o'clock on Friday night, so this may be changed, but isn't it true that the powers and responsibilities that your draft confers upon the review board includes the power and responsibility to determine whether the local government's ordinance is consistent with their draft?
Correct. So happy to take a recommendation if you'd like to see clarification on local government representation on the board for that particular decision.
Mr. Chair.
I'm Delegate Sullivan.
Yeah. Doing legal research during a meeting is never wise, but there was a pregnant pause when someone asked the question, have we ever required a model ordinance or done model ordinance in our code? I've just quickly searched model ordinance. There are several of them, I would say even lots of them, some of them having to do with charitable taxation, model ordinances relating to bow hunting, model ordinances relating to hunting with firearms, model ordinance relating to erosion control and stormwater management. So we've not made up, this would not be the first time this body has ever passed legislation relating to model ordinances.
In any of those instances, I wonder whether the body creating the model ordinance is also the judicial body that determines whether whether the ordinance that's adopted complies with their intent. It seems like we're just giving a lot of power, top to bottom.
We'll have someone look at that, I'm sure.
And
I haven't read
I
it.
just
The
wonder,
answer is I don't know.
While
Fair enough.
we have the development of model ordinances, are there other instances where we require a locality to adopt a model ordinance? We might develop them, but are there other instances where we require that they be adopted?
Well, I don't think Mr. Chairman, this bill doesn't require that they be adopted. They can be different.
But they have to be
In fact,
consistent.
it makes very clear that they can be different, but they have to be consistent with.
Right.
But they could be, for
a
instance,
range
they
of
could be,
parameters.
within a range of parameters, they could be better than, or some people's views, better than the model ordinance. So
Senator Obenshine.
Didn't we go down this path with bathroom policies? We required, and I'm not joking, I mean, we required every school division in Virginia to adopt a model bathroom policy. And over the course of the past 5 years, there have been few issues that have been more controversial, more fraught with litigation, and created less stability than that. I mean, we're interested in trying to create predictable environment, and it seems to me that this is abdicating to this unelected review board of volunteers a lot of responsibility that is not enumerated in this statute, and creating a lot of avenues for unpredictability in an area where the impression I got was that we were trying to create predictability. So, you know, if we want to do something here, I say just do it. I oppose it. You know, what I get the sense is that you want to be able to force localities to grant these permits. And we're going through an elaborate exercise in drafting a statute that pretends like we're not forcing localities to do something in order to, you know, create some window dressing to make it look like something it's not. You know, it's just not. So.
Senator Obenshine, I appreciate all your concerns, but aren't we creating a predictable environment where we are saying that one body has the ability to decide whether the ordinance adopted is consistent with the ordinance that they've modeled? That's exactly what we're doing.
Department of Education.
Mr. Chair, recognizing we do probably have public comments today, but I did want to offer that we have contemplated other options for the creation of the model ordinance, that we could direct a set of state agencies to convene work groups that, you know, works with a variety of stakeholders, and that is the model ordinance, and then it's the review board that then does the judgment call as to whether or not the local ordinances that have been adopted are consistent with that. So you could consider separating
What
those.
sort of agencies have you considered?
We considered, Mr. Chair, the Virginia Department of Energy and the Department of Environmental Quality to work together. But I may, you know, draw your attention to that their directors are also appointed to this review board. So you have state agency directors predominantly are the ones or their designees that are making up the body of the review board. So they are, you know, extensions of state government.
Mr. Chairman, one last question. Thank you. So Ms. Hearn, the legislation as drafted does not require that the model ordinance require localities to approve any particular application.
No, sir.
They'll still have the discretion not to if it's a bad application. It doesn't meet the criteria in their, or the ordinance they adopt.
Mr. Chair and Delegate Sullivan, that's correct.
Unless that is the review board disagrees with their position,
Yeah.
in which event the review board's presumptively right and the local government is presumptively wrong.
I would take it, Mr. Chair. I think the senator, I'd agree with the senator up until the last sentence. They would have an opportunity to prove that they were in fact right and that the review board got it wrong. They would have that opportunity in litigation.
There's a rebuttal presumption, so we'll come back. Have we gone over the entire bill?
The entire bill, Mr. Chair, is in the packet and it's posted online. Certainly, we've gone over what we believe are the highlights of the changes, and otherwise, we've discussed components of the bill at prior meetings. Yes, Mr. Chair. Mr. Chair, I believe my understanding is that the vote can happen at the main commission meeting at noon. So I'm not sure if it is, it's up to your prerogative.
My sense, and I might be wrong, but my sense is that this is still a work in progress, and that it's difficult for us to take a vote until we have some sort of final product to look at. Even that is not a final product because we have a legislative session to deal with.
Mr. Chair, with all due respect, we do have a deadline where a request recommendation to the General Assembly, one way or the other from the Commission, we would need to make that before 10 a.m. on the 8th.
Okay.
Mr. Chair,
Senator Obenshain.
I've heard on many occasions this bill just isn't ready for prime time. You know, there is no deadline for a bill that's not ready for prime time.
Now we have public comment. I appreciate Senator Obenshain's views, and there are certainly other views. But now we've come to the public comment section, and anybody who's in the room will have firsthand, but you'll have 3 minutes.
Thank you, Mr. Chair.
Thank you. Okay, let's start. Okay.
Mr. Chairman, members of the committee, Tom Dick with the Municipal Electric Power Association of Virginia. I just wanted to say thank you for the members for your consideration of the concerns we raised, especially Delegate Sullivan's suggestion and especially thanks to this commission staff, Carrie, because she really did not have a lot of time to work on this, the issue that we've raised. So I appreciate that, and we look forward to working to address the issue. So thank you very much.
Thank you so much. Next.
Mr. Chairman, Kyle Shreve on behalf of the Virginia Farm Bureau Federation and the Virginia Forestry Association. We still have concerns with the bill. It still contains various elements of some of the bills that were included last year, including Senate Bill 697, that we just have a hard time with because it does have the potential to overrule local land use decision-making and make it difficult for conservation planning, specifically with unreasonable restrictions, including amount, density, size. Those, if an overriding review board model ordinance overrides the locality's ability to do conservation easements and target conservation,